Hello everybody, welcome to iExamBee. I am Vidhika, Law Faculty at iExamBee. In our free mock test series, we are discussing questions from important sections of various acts. और आज की वीडियो में हम टॉपिक पढ़ेंगे क्रिमिनल प्रोसीजर कोड. We will cover two chapters, maintenance of public order and tranquility and preventive action of police. These are chapter 10 and chapter 11 of the criminal procedure code. Section number 129 to section number 148 deals with chapter number 10, that is maintenance of public order and tranquility. And in chapter number 11, preventive action of police, section 149 to section number 153 are there. Starting with the first question, who among the following cannot demand any unlawful assembly to disperse? The correct answer here is D, constable. This is given under section number 129 of criminal procedure code, dispersal of assembly by use of civil force. तो जब भी किसी एग्जीक्यूटिव मजिस्ट्रेट या फिर ऑफिसर इन चार्ज ऑफ पुलिस स्टेशन को, या अगर कोई ऑफिसर इन चार्ज ऑफ पुलिस स्टेशन नहीं है, तो एनी पुलिस ऑफिसर नॉट बिलो द रैंक ऑफ सब इंस्पेक्टर, they may command any unlawful assembly or any assembly of 5 or more persons likely to cause a disturbance of public peace to disperse, and it shall thereupon be the duty of the members of such assembly to disperse accordingly. अगर वो disperse नहीं करते हैं, so various purposes can be opted. If necessary, arrest and confining the persons who may form part of it in order to disperse such assembly. Question number 2. If a person is a member of armed forces and has ordered to disperse assembly by use of force, he cannot be prosecuted for those actions. He can be prosecuted only with the prior sanction of district magistrate in whose jurisdiction he was present. He can be prosecuted with the sanction of central government. He can be prosecuted with the sanction of state government. No prosecution can be instituted in any criminal court. The correct answer is C. He can be prosecuted with the sanction of central government. This is given under section number 132 of Criminal Procedure Code. This section clearly says कोई भी prosecution नहीं होगा against any person for any act which is purporting to be done under section 129, 130, 131 in any criminal court except with the sanction of central government, where such person is an officer or member of armed forces, or with the sanction of state government in any other case. Also, no executive magistrate or police officer acting under any of the said sections in good faith, or no person doing any act in good faith in compliance with the requisition under 129, 130, or no officer of armed force acting under section number 131 in good faith, or no member of armed force doing any act in obedience shall be deemed to have committed thereby any offence. Question number 3. Who can make conditional order under section number 133 to remove any unlawful obstruction or nuisance? District Magistrate, Subdivisional Magistrate, Chief Judicial Magistrate, both A and B, all ABC. Correct answer here is D, both E and B. District Magistrate, Subdivisional Magistrate, or any other executive magistrate who is specially empowered in this behalf by the state government on receiving the report of a police officer or other information, or on taking such evidence as he thinks fit, considers कि कहीं पर कुछ obstruction हो रहा है which is disturbing public peace, या फिर कोई और reasons. There are some reasons, some points given, तो वो आप देख लेना. Such magistrate may make a conditional order requiring the person causing such obstruction or nuisance, or carrying on such trade or occupation, or keeping such goods or merchandise, or owning, possessing or controlling such building, tent, structure, substance, tank, well or excavation, or owning or possessing such animal or tree within a time to be fixed in the order, may order them to remove such thing, may order them to follow the conditional order. However, under subsection 2 it is clearly said, no order duly made by a magistrate under this section shall be called in question in any civil court. ये आपका section number 133 of criminal procedure code में दिया हुआ है. Moving to question 4. Power to issue order in urgent cases of nuisance or apprehended danger is given under, ये आप सब ने काफी बार सुना होगा, section number 144 which deals with curfew. कहीं भी अर्जेंट केसेस ऑफ न्यूसेंस हो या एप्रीहेंशन ऑफ डेंजर हो, वहां सेक्शन नंबर 144 लागू कर दिया जा सकता है. This can be done by a district magistrate, subdivisional magistrate, or any other executive magistrate who is specially empowered by the state government in this behalf. If there is sufficient ground for proceeding under this section and immediate prevention or speedy remedy is desirable, such magistrate may, by a written order stating the material facts of the case and served in the manner provided by section 134, they may direct any person to abstain from a certain act or take certain order with respect to certain property in possession or under his management, अगर उस magistrate को लगता है that such direction is necessary to prevent obstruction, annoyance or injury. इसमें सबसेक्शन 4 आपका बोल रहा है द टाइम पीरियड, नो ऑर्डर अंडर दिस सेक्शन शैल रिमेन इन फोर्स फॉर मोर देन 2 months फ्रॉम द मेकिंग और देयर ऑफ, हाउएवर देयर इज अ प्रोविजो, अगर स्टेट गवर्नमेंट को लगता है कि फॉर प्रिवेंटिंग डेंजर टू ह्यूमन लाइफ, हेल्थ और सेफ्टी, और फॉर प्रिवेंटिंग अ राइट और एफ्रे, then it may by notification direct that an order made by a magistrate under this section shall remain in force for such period not exceeding 6 months. तो वैसे 2 महीने के लिए है, extendable to 6 months from the date on which the order made by a magistrate would have, but for such order expired as it may be specified in the said notification. Question number 5. Power of police officer to prevent cognizable offence is given under. This is given under section number 149 of the Criminal Procedure Code. 149 clearly says that every police officer may interpose for the purpose of preventing and shall to the best of his ability prevent the commission of any cognizable offence. तो यहाँ पर this chapter is talking about the preventive actions of the police, preventive powers with the police. इसी में 151 talks about arrest. So 149 is saying that the police officer may interpose, may interrupt, or may take any necessary action for the purpose of preventing any cognizable offence. 151 says that the police officer may also arrest to prevent the commission of cognizable offence. However, whatever arrest is made under section 141, that should not exceed a period of 24 hours from the time of his arrest, unless his further detention has been authorized under the provisions of this code or any other law for the time being in force. Question number 6. Public notice under section 144A of Criminal Procedure Code shall remain in force for a maximum period of. The correct answer here is 3 months. Section 144A talks about power to prohibit carrying arms in procession और मास ड्रिल और मास ट्रेनिंग विद आर्म्स. तो अगर कभी डिस्ट्रिक्ट मजिस्ट्रेट को ऐसा लग रहा है दैट फॉर द प्रिजर्वेशन ऑफ पब्लिक पीस और पब्लिक सेफ्टी और फॉर द मेंटेनेंस ऑफ पब्लिक ऑर्डर, the district magistrate need to prohibit in any area the carrying of arms in any procession or organizing or holding off or taking part in any mass drill, he may do so. This public notice which is being issued in this section that may be directed to a particular person or to persons belonging to any community, party or organization. However, subsection 3 clearly says no public notice issued or an order made under this section shall remain in force for a period more than 3 months. तो maximum duration 3 months का है unless further extended. ये आपका subsection 4 में दिया हुआ है. State government को अगर लगता है for the preservation of public peace or public safety or for maintenance of public order, then they may direct that such notice may remain in force for a period not exceeding 6 months from the date on which. So this can be extended to a period of 6 months. Question number 7. A police officer may interpose to prevent any injury to public property. The public property under this section is. ये कौन सा section है? सबसे पहले public property में movable, immovable और immovable public landmark क्या क्या आ सकता है? The correct answer here is C. Both movable and immovable property can come. ये आपका section number 152 of Criminal Procedure Code है which is related to prevention of injury to public property. Then the next question is for the purpose of disputes concerning land or water, the expression land or water does not include. Correct answer is E. All are included. ये सभी included हैं in the definition of land or water under section number 145 of Criminal Procedure Code. 145 talks about procedure where dispute concerning land or water is likely to cause breach of peace. अगर land और water से related कोई dispute है तो इसमें subsection 2 clearly says the land or water includes buildings, markets, fisheries, crops or other produce of land and the rents or profits of any such property. So this was all. In the next video, we'll be discussing questions from the next chapter. I also want to tell you here about the IBPS SO Law online course, जिसका नया बैच 10th of April से स्टार्ट हो रहा है. अगर आप इस कोर्स में इंटरेस्टेड हैं, you can download the class schedule from the description. आपकी क्लासेस 10th of April से स्टार्ट होंगी. There will be daily live classes which will help you study and prepare for the exam in the matter of 3-4 months. And after that, you will have enough time in your hand for revision, for practice, so that you are well prepared for the upcoming exam. आपको इस कोर्स में लाइव क्लासेस, प्रैक्टिस टेस्ट, स्टडी मटेरियल, समरी शीट्स, क्रिस्प वीडियोस, इंटरव्यू गाइडेंस सब मिलेगा. So you can check out the demo of this course. For any query, you can also reach out to us on this number. आप अपनी क्वेरीज को नीचे कमेंट बॉक्स में भी लिख सकते हैं. अगर आपको कोई गाइडेंस चाहिए, कोई डायरेक्शन चाहिए तो भी आप हमें इस नंबर पर रीच आउट कर सकते हैं. We at iExamBee help you prepare 50% faster with a crisp and concise content. Subscribe to our channel to stay tuned with this free mock test series and with other information relating to law exams. Thank you.